Hello everyone, welcome to the CTV News on Calabash TV and on the Wave Radio 94.5. I am Lisa Joseph. Well, the court has thrown out the case against Alan Chastanet in the misuse of Taiwanese funds, a matter, and ordered that the government pay his legal costs. In December of 2013, the Attorney General's Chambers filed a civil action against the former tourism minister and the current UWP political leader, alleging conduct amounting to a breach of his fiduciary duties as a minister of government in bad faith and or constitutes misfeasance in public office. Alan Chastanet has welcomed the ruling, saying that the Attorney General's office was misused in a specific attempt to tarnish his name.
I have never misused government's monies for my own personal gain. I have only always tried to achieve the better good for everyone. So I'd like that my works continue to speak for themselves. And again, I'm very grateful to the courts. I'm very grateful to Mr. Patterson for what has happened so far. And I'm looking for the final completion, looking forward to the final completion of this case.
The judge in his decision focused on the misfeasance point. While the breach of fiduciary duty point has not yet been formally dismissed, Mr. Astafan, who is representing the Attorney General, had indicated that he wanted to have an opportunity to review the judge's decision in order to make a decision for the Attorney General as to what their next steps will be. And one possible decision may relate to the outcome of the breach of fiduciary claim. So that as it stands, the breach of fiduciary duties claim has been seriously undermined by the decision of the judge. I would go as far as to say that they cannot succeed based on the ruling of the court. But I don't want to traverse on that issue because the case is still pending.
According to the statement of claim, Chastanet, while a minister of government and a UWP candidate, had allegedly requested the sum of $38,119 of public funds for the unlawful purpose of a campaign and political event for his personal and political benefit or the benefit of his political party. It further claimed that Chastanet knew or ought to have allegedly known or was recklessly indifferent that the conduct in question was unlawful. But Mr. Chastanet's team argued that the Attorney General's Chambers has no standing to file the suit.
The Sophia Town Council, as it then was a council, a body set up by statute. It had its own existence. It could own property. It could sue and be sued in its own name. So it was it was almost like you or me, and a separate legal personality. And therefore, if anyone sustained a loss, if the allegations were to be true, if anyone sustained a loss, it was the Sophia Town Council, and that would have been the proper person to bring that claim. The fact is that the Sophia Town Council did not bring any such claim, and essentially the court is saying that the Attorney General had no right to bring that claim on its behalf.
The Barbadian Queen's Council is of the opinion that should the government appeal the decision, it would be an exercise in futility, adding that the political overtones are obvious. Mr. Patterson insists that the claim was frivolous and ought not to have been brought before the courts. Alan Chastanet also believes the decision has vindicated the former UWP government's management of the Taiwanese funds.
There's always been a claim by Dr. Anthony that those funds needed to go into the consolidated fund. I mean, so, and that all funds coming through were public funds and that of the government. This clearly now substantiates that that's not necessarily true. The funds, once put into the town council, became the asset of the town council. And so the donation, while to the government of St. Lucia, was administered by the town council and therefore falls under the responsibility of the town council. So this claim that something illegal was done I mean, I think that that discussion needs to come to an end based on the judge's decision today, that there was nothing illegal in putting the monies in the town council.
Also called into question is the forensic audit report that formed the basis of the suit against Alan Chastanet.
Is rather than that report going to cabinet and then cabinet deciding to table it in parliament, it should have gone to the DPP, or it should have gone to the Auditor General, and that they would have validated the report. So, you know, clearly there was a breach in process. And this that's what makes this case very frivolous. This is what brings into question as to whether they were looking to seek justice or they were playing politics.
We've always taken the view that the committee that was formed to carry out that investigation was never properly constituted, that it was no function of that committee, or the government had no right to form a committee of that nature in order to carry out investigations. The Constitution provides the machinery by which investigations of that sort could be conducted, and the committee was not constituted in accordance with the Constitution. So that we say that the report that emanated from that committee was totally valueless. The conclusions themselves were questionable. The court itself made no ruling as to the effectiveness or validity of the report, but the judge did in fact make some comments which coincided with our view of the law.
And the government was represented by Queen's Counsel Anthony Astafan.